Today we have Dr. Sarah Wallet, our Chief Medical Officer and one of the plaintiffs in the lawsuit. She'll tell you more about what happened today. We also have Hannah Swanson, who is a staff attorney from Planned Parenthood Federation of America. She's also one of the lawyers representing us in this case. Hannah will be available to answer questions, but we'll start with some remarks from Dr. Wallet.
Thank you all for being here this afternoon. Today was a really exciting day for me and for Planned Parenthood of Michigan and our patients. Today, Michigan's Court of Claims granted a preliminary injunction to block enforcement of Michigan's 1931 felony abortion ban, which was never repealed or enjoined. This ruling means that the law cannot be enforced while our case proceeds, and people in Michigan can continue to access safe and legal abortion care as they have for nearly 50 years. We filed this lawsuit on April 7th and asked the court to block this law because it is unconstitutionally vague and violates the rights to liberty, bodily integrity, equal protection, and privacy under the Michigan Constitution and state civil rights laws. We also asked the court to affirm the right to abortion in our state constitution. 2 weeks ago, the leaked Supreme Court draft opinion confirmed our worst fears, that the court is prepared to overturn Roe v. Wade and end the constitutional right to abortion after nearly half a century of federal protection. The consequences of losing Roe would be swift and devastating, and 26 states could quickly move to ban abortion, Michigan being one of those. We are at a crisis moment for abortion access, but today's ruling means that no matter what happens at the Supreme Court, abortion access remains protected in Michigan, while our full case proceeds to block this antiquated law once and for all.
If folks don't mind using the raise hand feature to get in the queue, and we'll moderate that. First up, Dave.
Hi, thank you for doing this today. I appreciate it. This is a logistical legal question. I know that Attorney General Nessel has said that she will not appeal this ruling, but can someone talk through the concept of maybe somebody intervening and trying to appeal and what that might look like and how you're preparing for that possibility?
Hi. Sure. Thanks, Dave. So yes, we have heard that Attorney General Nessel is not planning to appeal this decision. We don't know whether the legislature or somebody else would want to intervene in this case. If they did, they could attempt to appeal the court's decision to the Court of Appeals, and they could ask to put the court's decision on hold, and we would brief that request if they did so. If nobody intervenes and appeals, then this case is going to continue in the Court of Claims, and we, of course, have asked the court to ultimately enter a permanent order blocking this law once and for all. The court's order today is a preliminary injunction, which means it blocks the law from taking effect while the case is ongoing. And at the end of our case, we want an order making that relief permanent. So that's what we're going to continue to fight for in the Court of Claims and on appeal if necessary.
Thanks, Dave. Rachel, you're up next.
Hi, this is Rachel Bryan with the Washington Post. Thanks for taking my question. And sorry if I missed this, but I was wondering if you could walk us through a little bit about the implications of the temporary injunction in Michigan, kind of the next steps, and then also if it has any broader implications in terms of if you think if there were lawsuits over other pre-Roe bans, that this could be a similar temporary injunction, etc.
Let's have Sarah talk about the impact in Michigan, and then Hannah can answer the broader legal questions.
This morning, I was planning for the possibility that abortion would be illegal in Michigan and we would not be able to care for any patients who needed abortion care within our state borders. And this afternoon, this means that I know I'll be able to continue to take care of my patients, that I'll be able to help them achieve their dreams and their goals by controlling their reproductive health decisions. For me, this is incredible. It is incredible for my patients, for our families, and for our communities in Michigan, that pregnant people will be able to continue to make these decisions for themselves, no matter what the Supreme Court decides in the upcoming weeks.
Yeah, and in terms of the legal implications of this decision, so as we've been discussing, this is a preliminary injunction, which means it blocks the law while the case is ongoing. And in terms of who is bound by this injunction, the court entered the order blocking enforcement by the Attorney General and all those under her control or supervision. So this means that local prosecutors cannot use the pre-row ban to go after abortion providers as long as the preliminary injunction is in place. And again, pending appeal, that preliminary injunction will stay in place while we continue to litigate the ultimate issue of the ban's unconstitutionality in the Court of Claims and on appeal. So this law protects Michiganders seeking abortion and Michigan abortion providers as long as our case is ongoing. And as Dr. Wallet mentioned, that means people will continue to have access to abortion in Michigan no matter what happens at the U.S. Supreme Court level, which is just a huge win and a huge relief, I know, for our patients in Michigan, for Planned Parenthood of Michigan's patients in Michigan. In terms of implications for other states, everything, there's a lot of variables that differ from state to state, but this is the first decision that has blocked one of these pre-Roe bans in the face of impending changes to Roe v. Wade, and it's going to be a state-by-state fight in the weeks and months and years ahead, and I think we will be excited to see what implications this decision has in other states and for the courts.
Thanks, Hannah. Joshua Sanchez, you're up next.
Hi, good afternoon. Josh Sanchez with WLNS 6 News in Lansing. So this is a bit similar to the previous question, but with this preliminary injunction, do you believe that this is essentially a sign of hope for other advocates in states that have similar laws that are still on the books that are only being blocked by Roe versus Wade? And along with that, do you think this is also serves as a sign to the justices ahead of the June 1st decision date?
So we have no way of knowing what the U.S. Supreme Court justices are thinking. So I think can't answer that question. I think I know that this decision provides hope to those of us thinking about abortion access in Michigan, and it's just a huge relief to know that patients will be able to continue to rely on this right that they've looked to for the past 5 decades, and to know that it's not going to disappear overnight based on whatever happens from the U.S. Supreme Court. So again, I can't predict what's going to happen in other states. As you've alluded to, there are a number of states that are poised to ban or severely restrict abortion if the Supreme Court does overrule Roe v. Wade, and there's no way to know how that will play out. But I think for now, this decision in Michigan is a massive relief and a real beacon of hope.
As an abortion provider, I feel a lot of hope. For the last 2 weeks, I've been dreading the possibility of waking up in the morning and having to tell my patients that I couldn't take care of them anymore because abortion was illegal in Michigan. And I feel so much relief that isn't going to happen right now, and that I'll be able to continue to care for all of those patients in Michigan who need abortion access, and the rest of the providers in Michigan will be able to as well. So a huge sense of relief. I'm so happy to hear this news. I was scared for my patients and what it meant for them.
Thanks, Sarah. Beth LeBlanc.
Hey, thank you for taking these questions. I was hoping you could clarify something on the legal side for me. My understanding is that because this is filed in the Court of Claims, only a state actor can intervene as a defendant in this case. So in order for an actual appeal to go forward, at this point, it could only come from the state legislature, correct? Considering that Attorney General Dana Nessel has said she won't appeal this.
So that's correct that in the Court of Claims, only statewide defendants can be involved in litigation in this particular court. And so if the legislature did intervene, then they would be the ones to appeal. And so, yeah, we don't know if anyone will appeal, who will appeal, but if they did appeal, that would be, if they did intervene, that would be one way for an appeal to go forward.
Just a quick follow-up question on that. Do they have like a deadline by which they have to intervene? I know there was a deadline for amici, so I wasn't sure if they had one as well.
That's a good question, and I don't know the answer to it, but I can find out and let you know if you follow up.
Just a reminder for folks to utilize the raise hand button so we can make sure everyone's questions get answered. Okay, seeing none, I think we can wrap this up. If anybody has follow-up questions for Sarah or Hannah, please email them to media@ppmi.org and we'll get you responses as quickly as we can. Thanks, everyone.
Thank you.